Welcome. Thank you so much for coming to New Canaan Library and joining us for a collaborative event, the beginning of our Aging Successfully and Stressless-ly series. Tonight's first session is very exciting. We're going to be learning all about wills and trusts. But before I hand the mic over to my wonderful partner, Gina Blum, to introduce the speaker, I want to remind you all to silence your cell phones. Take a second. And also take note of our auditorium exits there and there. You can get right out of here and go right to the parking lot at the end of the program if you wish. And without further ado, I'm going to hand it over to the Director of Staying Put, Gina Blum. Thank you.
Thank you, everybody. I'm so excited to be here tonight. I'm so excited that all of you are here tonight. Staying Put in New Canaan is a nonprofit organization that helps New Canaan seniors to remain living confidently at home and keep them engaged in the community. We're so excited to partner with the library for this program, and it's the first in a series, so I hope that you picked up a flyer at the desk about the upcoming programs. This first session focuses on wills and trusts and features attorney Michael Nedder. So he is the managing partner of Nedder Associates. He founded the firm in 2011 after practicing law for 12 years here in New Canaan. Attorney Nedder was born and raised in Darien. He attended Fairfield Prep, earned a BS in accounting from Fairfield U, and then received his Juris Doctorate from Fordham University School of Law in 1999. Attorney Nedder is admitted to practice in Connecticut, New York, and the District of Columbia. He's also on the bar of the United States Supreme Court and is actively involved in the New Canaan Bar Association, where he used to serve as the vice president. He also sits on the Darien Bar Association, the American Bar Association, and the Bar Associations of Fairfield County, New York, and the District of Columbia. Throughout his career, Attorney Nedder has always been an active volunteer and community member, providing pro bono work and serving on the boards of various public and private charitable organizations. I've had the pleasure of having him on one of my boards, so please join me in giving a very warm welcome to Attorney Michael Nedder.
Thank you very much. That's a lot to live up to. I didn't quite realize that you had my full resume. I actually used to work here in New Canaan at Hawthorne, Ackerley, and Dorrance with Dana Ackerley. And Dana used to say he was Dana Clay Ackerley, and the clay was the mud in his name. So Dana was a great lawyer, good New Canaanite, and taught me how to practice law the right way as opposed to the wrong way. So tonight we're going to go over sort of a brief overview of estate planning. So that's our agenda. What's an estate plan? When and why plan? I don't have kids or a lot of assets. Do I really need an estate plan? And then we're going to go over various documents, a living will, power of attorney, and then wills and trusts. We'll also talk about a couple of other things that are important to be aware of as part of your planning, a financial snapshot, and we'll kind of go over what that entails. And then we'll talk about other assets that aren't controlled by your will or trust. So there are certain assets that are outside of the estate planning process, or outside of the will distribution, but are still necessary as part of the estate planning process. This is a broad field. There is a lot of different ways to do this. I'm going to tell you my experience, what's worked for clients, what hasn't worked for clients. I'm going to give you ideas of scenarios that I've seen, but there are a large variety of ways to plan. So this is not a Bible, this is not a treatise, this is just sort of, some of the things that I've seen and some of the documents that I think are necessary. So what is an estate plan and why is it necessary? So let's start with what your estate is. Your estate is everything you own. So when a person passes away, an executor marshals all their assets, puts them all together, and that comprises their estate. It includes everything from real estate to jewelry to cars, whatever it may be. A complete estate plan lets your family know your wishes. It needs to do a few things. One part of it is the living will, which deals with life-prolonging methods. So it advises your family as to how or you want your body treated if something happens to you. And by the way, this can be very depressing. So just try and keep a positive attitude. The power of attorney specifies a person who can make financial decisions on your behalf if you're incapable. The power of attorney isn't always dealing with incapacity. You know, we've had many of experiences where a husband's traveling and a wife is trying to do a financial transaction, such as a refinance of a home, and had to rely on that durable power of attorney. So it's a powerful document, and it's a very practical document. Obviously, under the will, you identify who's going to receive your property. It can be very specific. It can be very general. A lot of times we try and deal in generalities because we don't know what people are going to have when they actually pass away. And it directs your heirs how they receive property. So one of the things we're going to talk about are trusts under will and revocable trusts as part of tonight. A trust under will is basically, you know, you got the ne'er-do-well son and you don't want him to get, you know, $500,000. Well, you can put it in a trust and you can put a trusted advisor in charge of that money so that they're not getting it all outright. And then, but still, why should you plan now? It's a good idea to have a plan. If you don't have a plan, the state has one set up for you. And it's not necessarily what you want to do, or it may be exactly what you want to do. You know, when I meet with clients, I sit down and I say, okay, what are we trying to accomplish? And if the state's plan, which is a third to your spouse and the balance to your kids is more than sufficient for you, then great, we're done. But most people don't want that. So why plan now? So planning now allows you to choose how you will be cared for and who will receive your property. So the caring for is an interesting proposition, right? Your care is really a part of a conversation. The amount of care that you get in what you want for your care is an important conversation with your family. The documents can take you so far, but they can't get to the nuance of, I never want to be in a home, I never want, you know, my dog to go away, right? The planning doesn't get to that nuance. So you still have to have conversations with your family when you're doing your planning. As I said before, without a plan in place, state law or a judge in the state of Connecticut, the probate courts, that word is, the word judge in the state of Connecticut isn't as scary as it is in some other states. Your intentions and wishes may not be followed. Final resting place, again, that's in here. I generally tell clients, talk to your family. Do a prepaid funeral arrangement. You know, plan that outside. And then when should you plan? So here are some examples. We generally, as a rule of thumb, say every 5 years, but really it varies by family. You know, so if you have a life event, a marriage, a divorce, a birth, you discover a child needs special needs, or has special needs and needs special needs planning, make sure you incorporate that into your plan. This is a new slide for me. It was added by one of the attorneys in the office today, and they thought it was important because not everybody has, you know, a very large estate, and not everybody knows, you know, where they want things to go. So what do you do in those situations? So you make decisions, right, as you do with the rest of your life. So you want to make sure that your plan, as you develop it, you know, explores your wishes and explains to people what you want to happen. Again, on top of that, you still need to have conversations because there's no way to have it all in the document. One of the things that people don't realize, you know, the first question you get from a client is, how much is this going to cost? And the reality is, a properly drafted will saves you money. The idea is to avoid costly probate, to avoid expensive probate proceedings. And we'll get to this in a little bit because everybody's got to go through probate, and I know you've all seen late night trusts or late night commercials where you use a living trust and it avoids probate and everything's great. That's not the reality of how that works, but we'll get into that. Planning also allows you to prepare for medical decisions in the future. So the living will appoint someone if you're incapable of making a decision, someone that can make those decisions on your behalf. And then the reduction for family disagreement when your intentions and desires are clear. I wish there was a sort of magic pill that you could give all the kids and keep them all happy. Well, there probably is, but that's a different seminar. Families fight. Kids argue. I have 3 children of my own. I'm one of 3 children. I've experienced it in my family with my brothers. I've experienced it with my children. It's just a fact of you know, siblings growing up together. But if you put together a plan and they hear what mom and dad or grandma and grandpa had to say, it changes the conversation a little bit. It's not perfect, but it changes the conversation. So that's the sort of overview. Let's get into some specific documents. So living will and advance directives. In Connecticut, we've got a bundled document that's provided under state statute. I use it on a daily basis. I think when the state legislature gives you a document, you should try and abide by that document and use that document. I'm sure all of you have seen other documents. I think one is called My 7 Wishes or something like that. There's a few other documents out there. Those are great. Have them. But also do what our legislature put in place. It's important to follow that, because then if there is a contest, if there is an issue, if someone's upset about what you've said, you're using an approved document. So that document that we have is an appointment of a healthcare agent, a living will, which deals with your desires for the use of heroic measures. And it also appoints a conservator in the event that a conservator has to be appointed because you're incapable of managing your own affairs. So that's a pretty powerful document. So we appoint a person to serve as your agent for healthcare decisions. So if you go in, and this is the most common scenario where I see this, a husband goes in for a surgical procedure. And while the doctor's in there, he finds something else that he wants to investigate. But the husband's still under anesthesia. He goes out to the waiting room and says to the wife, I would like to explore this. And if the wife has an appointment of healthcare agent, the wife can make that decision. And they'll make you sign it anyways when you go into the hospital. So it's not really a scary document that's going to change your life, but it's an important one to have in the emergency situation. It defines the manner in which you want your body treated. So that's the sort of living will part. For lack of a better word, the pull the plug. I don't want artificial hydration. I don't want a feeding tube. You're allowed to do that. Now, it's an interesting sort of mental exercise. So when I was in law school, my moot court paper was on the right to die. And there is no right to die. And we've heard of Kevorkian and we've heard of states changing their laws to accommodate that. But in Connecticut, there is no right to die. There is a do not resuscitate bracelet that you can get if you're within 6 months and you're terminally ill. But there is no right to take someone's life. So why is that important? Because when you're doing your living will, you say, oh, well, if I sign this, then, the hospital's not going to put me on a ventilator. The hospital's not going to give me hydration. No. This is after all that's been attempted, and there's no hope of your recovery. So you get hit by the crosstown bus. The EMTs come, they resuscitate you, they take you to the hospital, they hook you up to all the machines. If at that point they determine that you're not going to recover, that's when this is used. And then, the last item is sort of the conservatorship piece. So if your doctor determines that you're incapable of managing your affairs, and by the way, it's a pretty high bar. I've had a lot of experience with people being or attempting to be declared incompetent. I mean, if you have a moment of lucidity, the court can find you competent. We've had people with years of Alzheimer's who the courts have found competent. So it's a pretty high standard. But when they find that, they can appoint someone to act on your behalf, and that's the conservator. The other document's the durable power of attorney. So in Connecticut, we used to have a little bit of a mix-up where the durable power of attorney also included healthcare decisions, and when mom and dad appointed 2 different people, there was a conflict. So Connecticut's fixed that, and the durable power of attorney deals solely with financial decisions. You can appoint whomever you like, sibling, spouse, child, whoever, but the important part to know, there are 2 types of durable power, there's multiple types of durable power of attorneys, but there's 2 that we use in planning. One is effective immediately, and the other is what's called a springing durable power of attorney. So the springing durable power of attorney requires some event to happen before it's enacted. A lot of clients say, that's a great idea, why don't we do that? Well, we don't, as planners don't love that, or I don't love that as a planner, I should say, because it requires a hoop that you have to jump through to make the document active. And there are a lot of scenarios I'm sure you could think of in your head where maybe that didn't happen, but you still want someone to be able to use it. I gave the example earlier of a refinance of real estate. Maybe the husband's traveling or maybe the wife's traveling and the other spouse is trying to close on a refinance. Well, without an active durable power of attorney, you can't do that. And if it's a springing durable power of attorney, you're gonna need a doctor's note to use it. So I prefer the one that's active immediately, but it is a very powerful, very dangerous document if the person you appoint is not trustworthy. So the will is sort of a keystone to an estate plan. It's really the document that outlines your wishes on how you want your property distributed, who you want it distributed to, and by whom it's going to be distributed. Will and the probate process are a public process. So that's something that not a lot of people are necessarily familiar with. So when I submit a will to the court for probate, that becomes a public document and anyone can read it. So a lot of times what you'll see for families who are doing things that are, well, let's just say it this way, they're doing things that they don't want the public to know about, they'll use a revocable trust. And really one of the benefits of a revocable trust is that it is not a public document. It's a sealed document and it's sealed in the court record. The probate courts provide laws for court filings and creditor deadlines. So one of the great things about probate is you extinguish all the debt that the estate owed. So you file something called a return of claims and it removes or extinguishes all the debt as long as those claims are paid. So why is that important? Well, a lot of times, a year, 2 years, 3 years later, someone will come back and claim that they were owed money by, grandma or grandpa. The estate was probated properly and all the assets were listed and they were not listed and they didn't make a claim, they're barred from making a claim. And that's a really important part of the probate process. It also provides, probating a will also provides the court for dispute resolution. And you say, okay, well, we have the Superior Court. Why can't we just go there? You can, and it's a viable form, but the Superior Court is fraught with delay, expense. It's not a user-friendly court. It's designed for lawyers, not for the individual. Whereas the probate court, the Darien, New Canaan probate court, we stole it from you guys, we brought it down to Darien, but it's in the Darien Town Hall. And the Judge Ostendorf, is a practicing lawyer. And, hearing deadlines are 10 days, not 6 months. So it's a very user-friendly, and the clerks are, this is going to be recorded, so I should say this, the clerks are amazing. They really are the backbone of the court, and they really help the average person use the court. So they don't cater to lawyers. They don't make it a closed court. They make it very open and easy for you to access. And so when we talk about the court venue for disputes, well, when the kids fight, we drag them all in front of the judge and say, you tell your side, you tell your side, no rules of evidence, none of the formalities of court, just talk, and it gets resolved. And so it's really a really nice process that the state of Connecticut has. Hopefully no one's in New York from here, because New York is the exact opposite. The surrogates court in New York is not user-friendly. I'm licensed to practice in New York, and hopefully no one will see this, but those courts are much more difficult to operate in. And so, we really are privileged to have the court system that we have. The other thing we're going to talk about are trusts. So trust is a legal entity that holds your property for the benefit of your beneficiaries, right? So that's sort of the canned term. Trusts are sort of amazing instruments. They are all, the whole body of trust law, although there's a uniform trust code, it's all based on English common law. So it's a very old and not frequently changing body of law. And you say, oh, well, that's great, so it must be very easy to practice it. No, because it's very nuanced. There are a lot of rules, there's a lot of what you can and can't do, and then you add the Internal Revenue Service. And when you add that layer on it, the whole trust practice becomes much more complicated and interesting. So what can a trust do? The honest answer is pretty much anything. You've got a special needs child that you want to make sure continues to get benefits. We've got a trust for that. You've got a spouse who needs care, but you want to deplete the assets for Medicaid. We've got a trust for that. You want to make sure that a addiction-riddled child doesn't have access to a lot of money. There's a trust for that. They can pretty much do what you want. So when clients come in and say, what should I be doing? I say, I don't know, tell me about your family. What do you want to accomplish? That's what that's the beauty of the trust document. Now, this is what we talked about before. So assets in the trust are not subject to a portion of the probate process. So you'll see on TV that you'll see on, or hear from other attorneys that trusts are not subject to probate. That's technically correct. The problem is, in the state of Connecticut, in the federal government, when you die owning an asset, they automatically have what's called an incohate lien on that asset. And the only way to release that lien is through the probate process. It requires the filing of a CT 706 or CT 706 NT and supplementing that with a federal 706. So those are state tax documents and not really important to the layperson, but the important part is you can't release those liens without the probate process. So what does funding a revocable trust do? A couple of things. One, if you've got a girlfriend or boyfriend that you're trying to provide for, it's not a public document. It's a document that can be seen between your trustee, and that's it, right? So it's not a public document. That's a great thing to certain people who are doing things that they don't want other people to find out about. And the reason I bring up the girlfriend or boyfriend, one of the first things I did when I started practicing is I had to sit down with a widow and explain to her that the New York apartment was going to Jill whatever. Not a fun experience, but that's the planning that was done. And it wasn't my planning, it was another attorney's planning, but that would have been a great use for a revocable trust. It's a private distribution, nobody sees it, it doesn't become part of the public record. The part of the probate process it avoids or streamlines is the transfer of assets. So one of the things that the probate court supervises under a will is making sure that the assets get into the buckets where they're supposed to go, whether it's to the kids or to the nieces and nephews or aunts and uncles, whatever it is, whatever the distribution is, the probate court monitors that distribution. A revocable trust takes that out of the hands of the court and says, nope, that's my trustee's job. So that's the real sort of benefit to a revocable trust. And people who tell you that a revocable trust avoids all of this probate, they're partly right. Private transfer of assets, I think I talked about, and private provisions of the trust I've talked about. So some thoughts when you're doing this planning, right? You've got some appointments to make. The executor is the person under your will, and I kind of refer to them as the interim CEO. They step in, they put together all your assets, and then they distribute them out the way you've described, right? They're not really making any major life-changing decisions. They're just implementing your wishes. You've got a trustee for either a revocable trust or a trust under will. So the trustee is a trusted advisor. They're a person who has a long-term role. In Connecticut, we got rid of the rule against perpetuity, so a trust can go on for, I think it's 899 years now. So that's a long time. And that's a long time to have a trustee. So you want to make sure that your trustee is someone that you trust, right? It's an important role. It's more of a financial role. I look at trustees more as like a CFO of a company, right? They make financial decisions. They engage investment advisors to help them make investment decisions. In wills, we see trusts under wills quite often. It's just an easy planning technique. So if you don't want to go to the time and trouble of drafting and funding a revocable trust, you can just put you can put a trust in your will as a provision of the will. Usually where we see those, supplemental needs trust for special needs. We see those for trust for minor children. We see those for trust for children that you think may have a problem, but you're not quite sure. All of those sort of end up in the will. And sometimes you can even give discretion as to whether they're funded or not funded. Probably not an issue in here, but worth mentioning because it's an important part of planning, guardians for minor children. So who takes care of the kids if mom and dad are gone? And you guys would probably be on the receiving end of this. So, you know, having your grandchildren coming to live with you or your, you know, other family members coming to live with you. And again, I said this before, but I'll say it again. It's really important to have these conversations with family. You know, don't just put someone's name in there because you think that they do a good job. Have a conversation with them. Explain to them what they're doing. Explain to them what the role is. Have them call the lawyer and have the lawyer explain it to them. But the key to all of these appointments, they don't have to accept it, right? So you can appoint someone your trustee or guardian or executor. There's no obligation that they accept it. So you want to make sure that you have that conversation so that you're getting someone to fill that role. Because a lot of times we see where that role's not filled, or it gets filled by the court, or it gets filled by some person you didn't anticipate would be in that role. There are a variety of other planning vehicles. Listed here, I have irrevocable trusts. So irrevocable trusts are trusts that basically take assets outside of your estate. And so we use those in planning where we're trying to reduce the size of an estate, or we've got a family property we want to make sure we preserve for generations, things like that. Irrevocable trusts, by the name, they are irrevocable. So you can't amend, change, revoke. So once you put an asset in there, it's in there. So you want to be very careful with irrevocable trusts. Life insurance trusts, a product we see a lot. If you fund it properly and the life insurance trust owns the policy, and depending whether it's an existing policy or what, a life insurance trust can be outside of your estate. So if you've got, and we'll see the taxes in a minute, but if you've got a taxable estate or you've got an asset that you want to plan with like that, you can use those life insurance trusts. And then I spent my entire law school career doing partnership law, corporate taxation. It was very dry and dull stuff, but I get to use it in the planning world with limited liability companies. You may have heard of family limited partnerships or limited liability partnerships. The limited liability company has become sort of today's easiest and most efficient model to plan with. Basically, we use those for putting a wrapper around an asset. So let's say you have a house in New York, but you live in Connecticut. Well, that New York property requires that you do New York ancillary probate. So what do? We put the New York property into a limited liability company. It's now membership units. Those membership units don't require that ancillary probate. So it's a really, that's one of a variety of uses, but it's a really powerful tool as far as part of the planning process. Some other things to consider as you're going through the planning. A family balance sheet. And I know it's boring and not fun, but if something happens to both parents and the kids are left to try and find where the assets are and find where things are and what accounts are and all of that sort of stuff, it takes what could otherwise be a very simple process and it makes it very stressful. And I think part of this series is eliminating stress. This is one of the areas you can very easily eliminate stress for your family. January through March are good times because annual statements come out. So a lot of times when we can't find assets and we don't know what's going on, kids are sitting there monitoring mail to find out what's out there. It's not a great method for it, right? So we encourage, even if you just do it on your own, put together a balance sheet, put together a list of assets, put together, as much information as you think is necessary for them to go and find it. And it doesn't have to be full account numbers, it doesn't have to be PIN codes, it doesn't have to be all that sort of stuff that, you know, some thief would find, but just enough so that they know, okay, there's something at Northwestern Mutual, let's go there. There's something at Citibank, let's go there. There's something at Wells Fargo, you know, just to sort of give them the treasure map. Organizing assets in liability. So really, if you kind of do that balance sheet, you're just organizing, you know, all right, here's what I have and here's what I owe. Because the what you owe is as important as what you have, because it's all got to be dealt with. So we're going to talk about special assets in a minute, but as part of your planning, and we can kind of do these together, you want to make sure that your beneficiary designations are correct. Certain assets, a 401k, a life insurance policy, an IRA, an annuity, they don't pass under your will. They pass by the terms of the contract with that financial institution. So that's really important, right? If you've designated your ex-wife as the beneficiary of that, they have no recourse but to make that distribution. And there's some exceptions there under statute, but it's really a powerful designation. So you want to make sure you get that right. And you want to review those. So special assets, is the same idea, right? You want to make sure that you have the beneficiary designations. This gets into a sort of a level of a depth that's probably not appropriate for this evening, but you know, you can roll over 401ks, IRAs, SEPs. They're funded with pre-tax earnings, but they are subject to tax on distribution. So that's important to remember, that if you're giving that to the kids to roll over, that they're going to end up paying that income tax on the distributions. So it does come with a sort of a tax deficit involved in there. This is one I get quite a bit. Paid on death, which is a bank account, and transfer on death, which is a brokerage account. So another way you can structure your distributions out of your estate is by using these vehicles which are at the financial institution. So like a 401k, like a life insurance policy, you can basically say to the financial institution, go ahead and transfer this to so-and-so when I pass away. You can also do joint accounts with rights of survivorship and things like that. But transfer on death and payable on death are a really inexpensive way to do planning, because it circumvents the entire probate process, again, to the extent of transferring assets. They still have to be, if you own the asset at your date of death, you still got to release that lien. And then we've got some tax considerations. So income with respect to his decedent is important, but make your eyes bleed if I actually go into the details of it. But basically, it's what you don't want to do is have an asset taxable in the individual's name, in the estate's name, and the beneficiary's name. So there's some workarounds that we do in planning to make sure that you don't end up with that situation, is the easy answer. Pre-tax assets will be taxed at some time, so those are IRAs, 401k. They have an inherent built-in tax liability with them. So when you're transferring those, you sort of just want to be aware that's going to happen. Estate and gift tax exemptions. So Connecticut, it might be slightly higher than that this year, but it's almost $13 million per spouse. So in order to need sophisticated estate tax planning, you've got to be worth more than $26 million. So that's a big hurdle to get over, right? So when we talk about planning, we usually talk about what are your wishes, what are you trying to do, what are we trying to accomplish? One of the things that's, I think, important in the gift tax exemptions is the annual exclusion. So each year you can give away $17,000 per spouse per donee. And so if you want to deplete your estate and you want to make sure your kids have money, you can do that on an annual basis without filing gift tax return, without having to notify the federal government. And then capital gains tax reduction. So one of the things that's become interesting in planning is you get a full step up in basis on your, well, there's some talk about this changing, but right now you get a full step up in basis on the assets that you own at your date of death. So let's say you bought your house for $100,000 and it's now worth, $500,000. If you die owning that, the capital gains tax goes away. If you sell it before you pass away, you end up paying the capital gains tax. There are some exemptions in there. You know, if you've lived there 3 out of the last 5 years as a couple, you get a $500,000 exemption. But so a lot of times in planning, we're looking at assets and the kids are saying, well, why aren't mom and dad just transferring those to us? And you're like, well, because the unintended consequences of a huge capital gains tax that they'd have to pay, that you'd have to pay if they didn't continue to own it. So it's become a really strange, you know, most planners are give it away, right? Get it out of the estate, let's reduce the taxable estate. Now with the exemption being so high and the step up in the basis, it's become a strange part of the planning. So that's about all I have for you guys. I'm sure
I think that's all we have time for right
that's
now.
fine. Yeah, and I can hang around afterwards if you have additional questions.
Yes, so this is going to be recorded and published on our YouTube channel in 1 week if you need to maybe rewatch. Thank you so much, Attorney Nedder, for this wonderful presentation. Very educational. We'll hope you join us with the rest of our series, continuing in 2 weeks for Should I Downsize? Should I Move? Okay, thank you very much.
And thank you all for attending. I really appreciate you taking the time this evening.